In its most simplistic and orthodox form, the doctrine of parliamentary sovereignty means that the parliament has the absolute power to make or change any law. Furthermore, no person or body in England can override these laws. This traditional view comes to us from the writings of Dicey. But before we look more deeply into this concept, we need to ask the obvious question. Why is there even a need for such a system of constitutional governance where the parliament is supreme and the country has rule of law? What if there was no principle or doctrine underlining the governance of a country? In a country, not having a constitutional arrangement will lead the government into implementing laws that are arbitrary in nature. Imagine being a citizen of such a country. How will you know what is expected of you in terms of acceptable behavior? Now imagine being an official of that country. You will have these limitless powers and you can exercise them however you please. The reality of the world is not very far from this imaginary world. There are dictatorships that are tyrant governments. There are inefficient governments with limitless powers and crippled parliament. And there are governments who, even though uphold rule of law, but have given too much power to the executive branch, like the police or government officials. In UK, we have a parliament that is sovereign and can enact any kind of law. In this simple view of parliamentary sovereignty, the only source of law is the parliament. And the courts are just interpreters and the government is merely an executor of law. Professor Weir points out that there are forces like war, state of emergency, and other forces that may work against the constitutional arrangement of a country. We will look at a case to see what he means by that. So let's look at the doctrine of parliamentary supremacy in more detail. There are two ways of looking at the doctrine. One is through a political lens and the other through a legal lens. Let's first look at the doctrine through a political lens. This political view is the same as described by Dicey. The parliament is the supreme lawmaking authority and it drives its legitimacy through elections. The majority party which wins the elections makes a cabinet in the parliament to form the government. The government is legitimate in implementing policies and procedures they had promised during the elections. The parliament plays a key role here. It keeps the government accountable and makes sure that the ministers in the cabinet are not overstepping their powers in implementing policies. This way, the parliament helps in keeping the constitutional arrangement well intact. This view can be summarized as the political constitutionalism. The reason it is political is because the view puts a lot of faith in the political accountability of the members of the parliament. The idea is, if the majority party failed to deliver the mandate it campaigned in the election, they will be booted out of parliament in the next elections. If we accept this view as the sole view of looking at the constitutional arrangement and ignore the legal view, what will be our next inquiry into understanding the parliamentary supremacy? We will be very much curious to know how the parliament works. In what manner does the parliament legislate and what form does the legislation take? This is known as the manner and form theory. The legislative procedure is governed by the Parliament Acts 1911 and 1949. What are these acts and what kind of rules do they mandate on the parliament? We will look at the legislative procedure in greater detail in later lectures. But for right now, we will keep our focus on understanding the doctrine of parliamentary sovereignty. So let's compare the parliamentary supremacy with the idea of a food chain. The politicians elected by the people are at the top of the food chain. They can prey on any legislative issue, but they still have to be careful in their living environment, which is the parliament, that includes their peers who will keep them accountable. In this view, the judges are looked upon as a non-democratic group. This group has no right to make laws of the land, as their actual job is to only interpret the laws passed by the parliament. The judges in higher courts are also seen as coming from wealthy backgrounds, holding degrees from elite schools and hired through a selection process and not through elections. Do you think this criticism can be minimalized through the election of judges by the people? In this political view, the EU is also seen as a barrier on the political will of the nation. Why do people in Britain have to follow the rules that are coming down from the Union? Is it fair that an elected official from Italy is voting on a policy that will have an impact on a British citizen? If we take a strict political view and the judges and the EU are thrown out of the picture, who is supposed to keep the Parliament accountable for its actions? The answer that emerges out of the political constitutionalism view itself is that the democratic process of elections and the internal working of the Parliament are enough to keep the Parliament in check. Now let's look at the doctrine of parliamentary supremacy with a viewpoint of legal constitutionalism. If you were to take a legal point of view instead of a political view, what will be your argument? What is at stake when the policy agenda is ruled by a majority and the only right way of governance is through a majoritarian mindset? Who do you think will be ignored? The voice of the minority. The danger then is that the marginal groups will not have a say in the legislative process and will be sidelined by the agenda of the majority. The only way the interest of the minority, especially where the civil liberties are at risk, is through the rule of law that restricts the supremacy of the Parliament to its own rules and procedures. The argument further states that the whole democratic process becomes illegitimate if the civil liberties are ignored, and the Parliament decides to become a tyrant by suppressing the people and corrupting the voting process itself. For example, what do you think will happen to the legitimacy of the Parliament if the Parliament doubles the length of its term? Will the argument that the elections are the best accountability for the Parliament be a valid argument when the elections have been postponed for another 5 years? The Parliament Act of 1911 fixed the term of the Parliament to 5 years. On the other hand, it is also important to remember that any act can be changed or abolished by an ordinary procedure of the Parliament. We can connect these arguments to the codification of law. We know that the constitutional arrangement is not codified in UK, but we can make the case that there are some laws that are constitutional in nature and are meant to preserve the core values of the society, and they should be codified and should be held above any institution, even if it's the Parliament. In this codified-driven legal view of the constitutional arrangement, the judges become the guardians of the constitutional values, and the Parliament can only make an amendment to the constitutional arrangement through a special procedure. In the US, the Supreme Court plays the role of a guardian that has the power to strike down any law that is unconstitutional. The judges assume this role by interpreting the Constitution. To argue whether or not codification is a safeguard, we can look at the US, where President Obama appointed 2 Supreme Court judges during his tenure who both were liberal. So we can argue that codification is not a safeguard, where although the rules are written in stone but are open to the liberal or conservative interpretation by the judges. In spite of these different views of looking at the constitutional arrangement, the Parliament has one of the most important jobs in the country, because the laws made by the Parliament affect every aspect of our lives. In this section, we will keep on exploring the supremacy of the Parliament. We will look at the doctrine as it is viewed by the courts and the government, and we will find out what are the sources of parliamentary supremacy. We will also look at the principles of implied repeal and entrenchment.